And then Mr. Giorno,
Thank you. Yes.
come on up. You're here on a couple of things, no valid operator license, but with valid ID, and then a seatbelt ticket. So I guess we'll start with, those are two things. And again, a valid ID, that's the same. You're free to go if you wish.
Oh,
Yeah, you can
okay.
go ahead and just go line up at the window.
I'll go rush it in.
You can stay if you want to. No one ever does when I make that comment, make that offer, but
Thank you.
Mr. Giorno, like, again, the license issue, that's a pretty cut and dried thing. You have a license now? It looks like you do. Looks like you got the license like 2 days later. And then, so how did you want to, so again, how did you want to proceed on the seatbelt ticket?
Well, I'd like to contest the hearing, Your Honor.
So you're contesting on this speeding ticket, but then mitigating on the valid
Seatbelt issue.
seatbelt ticket. I'm sorry, you're right. You're contesting the seatbelt ticket, but you're mitigating then the license issue?
I'm contesting it, Your Honor.
Okay, okay. Could you raise your right hand, please?
Yes,
You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Seatbelt ticket first. What, did you get a chance to review your police report?
I did.
Okay. Go ahead.
And I set forth a motion for discovery, and I had a couple of questions, and
Did you submit it? Give me just a moment. So you submitted a discovery request?
I did.
You did.
Yes,
Did you ever get anything?
I did. All I got was a printed tick the box return. I had two questions that weren't answered.
Okay, so what, give me just a minute.
Okay.
Okay, so the discovery, I hereby set forth a request for discovery concerning the above case.
Yes,
And then I also request any evidence that you're subject to the codes concerning this case. And you request any evidence that you're in any type of contract concerning this case.
yes.
Okay, so the discovery typically is a police report, an affidavit or some sort that says what happened out there. Did you get that?
I got a tick the box
Right, that's
print.
right. So that's the evidence there. And then on your, the codes, it should say on your infraction, where you were served with that, it has the, yeah, right there. You go look right next to there, they'll have the codes there.
Your Honor, I was asking for some evidence that subject to these codes. I got nothing from the prosecutor's office. I didn't get a reply to either.
Well, they don't have anything to that, about that, first of all. And secondly, I request evidence that you're in any type of contract concerning this case.
Yes.
There isn't any.
Right. So,
And so that doesn't have anything, whether you're in a contract or not. I don't know why people make this argument to me. I really don't.
okay.
But there's rules of the road. You need to comply with them. There's, you go on the freeway, you see all the people on I-5. None of those people have contracts to drive on the highway, but they're required to follow the rules of the road, including have a license and don't drive under the influence of alcohol, maintain the speed limit and all that sort of stuff. There is no contract of any sort. That's just the rules you got to follow. And that's been litigated quite, for a long period of time. And the absence of any sort of written contract or oral contract with anybody, I will tell you that that's not a winning argument. It's just not.
Okay, but returning to being subject to the codes, there was also no response from the prosecutor's office as far as being subject to these codes.
Again, anybody who drives on the road are subject to the rules of the road. I mean, they just are. You don't have and again, taking that away from the traffic, you're not allowed to rob a bank either. You're not allowed to assault people, but there's no, you just live under those codes. You don't have, no one ever came to you and said, hey, you're subject to the code that says you can't assault people. The same is true with driving. you have to be licensed. In order to be licensed, you have to take a test. You have to both driving and written. And then that when you choose to get on the road, you're subject to those, you're just subject to all the laws in the state, whether or not it's traffic or not.
I understand but there is no injured third party. You abide by the rules, no one gets injured.
That's, and again, I've heard that too, and I have zero idea where that comes from, because that's just not true. I mean, like, for example, then people could drive drunk as long as they didn't hit anybody, they're fine. But that's certainly not the case.
Well, that would be,
that
would be reckless driving.
And you can commit crimes without hurting individuals. I mean, just because no one got hurt, no harm, no foul might work in the NBA, but that's not in terms of the rules of the road. You have to comply with them. So again, the issue, and again, I will tell you what the issue is they're very narrow, right? What you're charged with is not having a license, but without identification, or not having license, but with identification. And so that's it. I just make a determination. The police officer said in his report, you didn't have a license with you. And then it looks to me like you got one shortly thereafter. And that's, did you have a license when you were driving or not? That's the only inquiry. The second inquiry is, were you wearing your seatbelt or not? That's all there is to it. And so that's what I'm asked to decide. So I can swear you in and I'll hear from you. And then following that, I'll read the report and then I'll make a determination on those two issues, whether A, you were wearing a seatbelt, and 2, you were operating while you didn't have, without a valid license at the time. And that's it. And you could mitigate, you could admit that, and that the license ticket, that's an expensive ticket. And so again, if you want to think about what you want to do, I think Mr. McIntyre, is probably taking a little bit more time than we thought, so I can take care of him. If you want to think about what I'm saying, maybe this is coming as news to you. I'll hear from Mr. McIntyre, and then I'll come back and hear from you. So, Mr. Giorno, where are we at?
This is
I've got one last thing I want to say about the prosecutor's responsibilities. Their response.
This traffic hearing is taking an unusual turn as the defendant challenges not only the citation itself, but the legal basis behind the traffic laws being applied. The judge is carefully explaining the limits of the court's review and what evidence actually matters in a case like this. If you enjoy real courtroom breakdowns, be sure to like the video and subscribe for more.
They're required to give you everything they have regarding this case. And this is all there is, just that police report and the citation. So there's no, this isn't a speeding ticket. There's no speed measuring device. There's no pictures or anything like that or video. It's just the officer's report saying that you didn't have your license and that you didn't have a seatbelt. So what do you want to do here today?
Well, I had a seatbelt on and I would like to.
So if you want to contest it, then I can't even remember now. Did I swear you in?
Yes, sir.
Okay. So talk to me about the seatbelt.
Well, the officer's report is fabricated hearsay. I say it's inadmissible hearsay, and I motion to strike because.
So hang on just a minute. Let me get the report up. How is it hearsay?
He says I admitted to it. I did not. Of course not. And I would like to see the video. I'd like to cross-examine.
There is no video.
Okay.
And if you want to, you need to make a request to have the officer present in order to do that. And if you want it, and then in the absence of having the officer present, I can decide it from the court rules are clear on that. I can rely on the report. I want to set it over for a period of time to most people ask for the officer to show up, hoping they won't, if you want my frank opinion. But if you want, I'll give you the benefit of setting this over to have so the trooper can appear if you wish to do that.
Well, I object to that, Your Honor, because I showed up today and it seems you.
But you need to, again, this is another example of you need to follow the rules. In order to have the trip, you have to provide a request for that in advance of the hearing. We never got the request.
Your Honor, I understand that it's the burden of proof is on the plaintiff.
True.
So the officer's not here.
That's
There's
true.
a failure to appear. So I can't cross-examine the officer.
But
He did say that it was videoed.
Well, they might not, they probably, again, on takes like this, we wouldn't have preserved that and sent it to the prosecutor's office. You didn't make the request to State Patrol to get that. You made a request to the prosecutor's office, what they had for the case.
Well, it's a little hard to discuss things with State Patrol.
What's that?
It's a little difficult to discuss issues with State Patrol when they are in a certain mode.
Okay,
So,
what do you want to do here? Again, I'm still not too clear.
Well,
if you want to contest the seatbelt, we can do that. And then tell me what happened out there. Were you wearing your seatbelt? And if not, why not? And tell me what the misunderstanding with the officer is. Well, go ahead.
well, the officer could not have seen what I was doing either way because he did a 180-degree wheel spin in the middle of Yelm Highway, where I've lived for 35 years, to pursue me. I, as far as I know, had a valid driver's license and have always had a valid driver's license. So I contest that I don't have any evidence from the prosecutor's office. I don't have any witness to cross-examine.
You do have evidence from the prosecutor's office. You have that report.
This is a print, Your Honor.
I know what it is. I'm looking at the same thing.
I have one, the original.
At the bottom of it, you can say it was certified under penalty of perjury. And then there's the officer's signature on there.
Well,
give me just a minute. Give me just a minute here.
Okay.
Yeah, the court rule says, with regard to the officer not being here, upon written demand of the defendant, at least 14 days before a contested hearing filed with the court and served in the office of the prosecuting attorney assigned to the court in which the infraction is filed, the prosecuting attorney shall at least 7 days before the court hearing we provide you with a copy. That's not what I'm looking for. In a minute. Oh yeah. On earlier in that same rule, a request that an officer appear at a contested hearing pursuant to this rule shall be filed in a separate pleading, and it may be directed. And then someplace else in this rule, it says, in the absence of that request, the judge, me, can rely on the police reports. And that is a police report. Yes, it's short, but that's what we have. And again, that's so. Do you have anything else? Because I'm ready to rule on these cases. Unless you, and again, I'll give you the opportunity to set this over and have the trooper present if you wish. You're here now. I don't have to, but I will give you that accommodation if you wish to take advantage of it.
So there's no prosecutor present, there's no witness present. I'm not having, doesn't seem I'm allowed to have a fair trial. I believe, if I'm not mistaken, it's an adversarial court system.
Right.
We have two parties. There is no injured third party. I still don't get an opportunity to cross-examine, and they have failed by default to appear. So I don't see why this should continue on.
So they don't, the prosecutor doesn't need to. They're not required to. And the fact that they don't on these infractions, again, they rely on the report. And so, and that's just what they do. And sometimes they do that to their peril. You don't know how I'm going to rule on these cases. And sometimes these reports are incomplete, or I don't know, you were here at 1:30, they didn't even file one. So the case was dismissed and the woman who was there just left. And that happens sometimes too. And so the rules allow for this sort of procedure. And like I say, I'm giving you the opportunity to have that trooper present if you want to.
At this stage, the judge is addressing the defendant's concerns about fairness and the absence of the officer in court. The key issue now is procedural, whether the proper steps were taken to require the officer's appearance. The court is focusing on the applicable hearing rules rather than the broader legal theories being raised.
Take it. And so you've complained about, he's not here, and I've tried to explain to you that it's not, there's certain things you have to do to get him or her here, and you didn't do them, but I'm giving you the opportunity to set this over so you can speak with them if you wish, and it's entirely up to you.
Well, I'm here for the hearing. I mean,
Right.
it's going to be a fair trial. I mean, you seem to be, arguing for the plaintiff, whereas
I'm not, I don't mean to be doing that. I'm just trying to explain to you what the rules are. And in certain instances like these, they don't have to do things. And so I'm not saying about the sufficiency of the evidence. I'm not saying, well, you should be convicted for, or be found adjudicated for, found committed for this reason or for that reason. I'm not saying any of that. I'm just saying these are the rules for this sorts of procedure. And if you perceive that as me being on the side of a big argument against you, I'm sorry about that, but that's not what I'm trying to do.
Well, this print that the officer gave me, I did not and was not able to see who was in his vehicle.
Okay.
So I have no idea who printed that up. I have no idea. There is no personal signature on anything. And yet again, I'm here and showed up and they don't have a case. They're not here.
Well,
I'm a little bit perplexed by that.
so here's what I'm prepared to do here today. With regard, you have two infractions here, and with regard to you're correct. You've shown up. I've sworn you in. I've listened to you testify. With regard to the seatbelt ticket, I'll give you the benefit of the doubt. It will be a finding of not committed on the seatbelt ticket. However, with regard to the license, based on the report of the police report, combined with the fact that on your ADR, which I'm allowed to look at, it looks like you were issued a license 2 days after this. It will be a finding of committed with driving without the license.
Your Honor, I forgot to bring my old license in. You can't read the date on it. I mean, it's just,
Okay, so again,
it sounds like an entrapment. It's not like the Department of Licensing sends you a notice because what license went in the laundry or whatever, you can't read it. And suddenly I'm just driving like normal, and it's like, oh, that's crazy. I couldn't even read it. And I'll bring it in.
I'm going to go back to, and I'm going to say this one last thing, and then I told you how I'm going to rule on these infractions, but I will respond to that in this manner. And that is, it's, again, when you get on the road, it's your responsibility to comply with the rules of the road. It just is. And part of that is it's your responsibility to make sure you're appropriately licensed. And I'm not seeing it. You're right. You didn't see that. I don't know what it looked like when it came out of the laundry, but that's going to be my ruling on this case. And so they'll be not committed on the seatbelt, and that'll be dismissed. It will be committed on the no valid operator license, and the fine is since you got a license shortly thereafter, I will reduce the fine. I'll chop the fine in half.
But I got a discovery.
The fine will be, and again, hang on just a second. The fine will be $280. And again, I tried to explain to you, that is the discovery, that police report, that's what it is.
But discovery did not say that I am subject to these codes.
Well, when you, again, I tried to explain that to you too. When you choose to get on the road, you're subject to the rules of the road. You need to
Well, I
follow them.
object. This is
Okay.
not fair.
You can object and you can
I
appeal
will
if you
take
wish
this.
also.
I will.
Okay.
I will. This is not fair.
You can give him a piece of paper. You can come up this and you can take this to the window and you set up payment arrangements, file your appeal or whatever you wish to do. That's fine. You're certainly free to do that.
You're acting as a prosecutor, giving me a bill. I disagree. This is not fair. This is not a fair trial. They didn't show up. So the onus and burden of proof is not on me. I'm not subject to these codes according to the prosecutor's office. So I'm not subject to a fine until we have a fair trial.
Okay.
Fair and impartial.
Okay, I've told you what I've ruled. I've tried to explain to you the rules of infraction hearings. They don't necessarily need to. Sometimes they choose to, sometimes they don't. They don't have to. They filed the police report. I can rely on that. The court rules allow that. I know you disagree with that, and that's
The officer doesn't even have the decency to sign his own name.
and you can come and take this and you can take that to the window and set up payment arrangements. Or if you want to refuse to pay it, it'll be an unpaid infraction. And I'm telling you what I've done here today, and that's going to be the hearing will be concluded.
You didn't offer me another option that you stated at the opening of this hearing. You didn't offer me a deferral.
I did offer you a deferral. You told me you were wanted to contest it. I mean, I clearly offered you a deferral. I thought I said that at the beginning. I went through all three options. And
At the beginning when everyone was present.
yeah, and I told everybody what their options are. And then when they come to the table, they tell me what they want to do.
Yes. Well, I was pursuing a line of contesting this.
Right, and that's what you did. And then I made my ruling. And I ruled against you, which is what happens here today. So you can come and get that or refuse to take it, whatever you wish to do, but this hearing will be concluded and that'll be it for this hearing.
This hearing centered on two separate traffic infractions, a seatbelt citation, and a charge related to operating a vehicle without a valid license, in possession at the time of the stop. Throughout the proceeding, the defendant repeatedly challenged the legal foundation of the citations, arguing that he had not been shown evidence that he was subject to the applicable traffic codes and questioning the lack of a contractual relationship with the government. He also objected to the absence of the officer and prosecutor during the hearing. The judge spent considerable time explaining that traffic laws apply to all drivers who choose to operate vehicles on public roads and that compliance with those laws does not depend on any contractual agreement. The court further clarified that under the applicable rules for traffic infraction hearings, certified police reports may be considered evidence, even when the officer is not physically present, unless specific procedures are followed to require the officer's appearance. As the hearing progressed, the defendant continued to argue that the police report was insufficient and that he had been denied the opportunity to cross-examine the officer. The judge responded by explaining the procedural requirements involved and even offered the option of continuing the matter so the officer could appear at a future hearing. Ultimately, the court reached split results. On the seatbelt allegation, the judge gave the defendant the benefit of the doubt and entered a finding of not committed, resulting in dismissal of that citation. However, on the license-related infraction, the judge relied on the police report and licensing records, indicating that a replacement or valid license was obtained shortly after the stop. Based on that evidence, the court entered a finding of committed. Although the judge upheld the license violation, the fine was reduced in recognition of the defendant obtaining a license shortly thereafter. The defendant strongly disagreed with the ruling and indicated his intention to appeal. If you enjoyed this courtroom breakdown, be sure to like the video, subscribe to the channel, and share your thoughts in the comments below.